Okay, good afternoon to everybody. Welcome back. What we are going to do this afternoon, we're going to look at another aspect of the welfare state, which is not necessarily only of the welfare state, but it is a characteristic of our legal systems, and especially when we compare legal systems. And what we're going to do is look at labor relations and legislation. So we're going to try and understand to what extent the working conditions from a legal point of view are significant in establishing the water system actually is. And we shall see this is a very important feature when we look at legal systems. Well, we look at important aspects, but then if we don't look at also to what the working conditions are, obviously we lose really the relationship between the law and its citizens. It's not only private law and criminal law, but it has very much to do with those who are working. So what I'm going to do now is going to start looking at a few slides. Just let me move here 1 second if I can. Okay, just 1 second. Let me open the. Here we are. Share screen. Here we are. Can you see the slides?
Yes.
Yes, yes.
Okay, that's fine. So just now, this is the first slide. Now, let's start as usual from sort of the origins. There's always been workers, well, as a matter of fact, we know from the Egyptian times and also during the Roman Empire, we know they were slaves. So they were people who were working and were as slaves. But let's look how in the modern ages, since the sort of after the year 1000, after the sort of 11th century, how were legal working relations governed when it came to sort of from a legal point of view. And generally, what happened is that until the end of the 19th century, and so well into sort of modern ages, the relationship between the employee and the employer were governed by ordinary contract rules. So it was a contract, there was someone who was working and was providing some kind of activity, of human activity. It could be a laborer or it could be an intellectual profession. Didn't matter. It was always regulated by private law. And as a matter of fact, in the European continent, it was considered as if it was rental. You were renting someone's work. Just as you could rent a horse, you could rent a house, you could rent a warehouse, you could rent something, a field. Well, you were renting people. So there was this very sort of pretty hypocritical idea that you had private autonomy and therefore anybody could rent out whatever they could sell their workforce. They could, their man or woman power, they could just sell it, and it was simply a contract like any other contract. Now, what did this mean? That clearly from with this approach, clearly the strengths, the bargaining power of the employer was overwhelming. The employee could not challenge anything, and obviously the conditions were set by by the employer, pay, how much he would be paid, how much the worker should pay, where the worker should pay, when and how performance should be provided. So all the conditions were somehow set out by the employer, and there was a clearly economic disadvantage between the employer and the employee. The idea, the basic idea: no work, no pay. So if you don't work, you don't get paid. So if you're holidays, well, if you take holidays, well, you won't be paid. If you're ill, well, you're not working, therefore I won't pay you. So it's very, very simple, just like a normal sort of performance of a contract. The idea that work was just like any other contract, and if you did not perform it well, you had no right to have the counterparty, which is the payment of the salary. So, and this situation, which went well into towards the end of the 19th century, was one of the bases on which the whole Industrial Revolution could go ahead, because you had workers who had no possibility of challenging the conditions, and obviously enterprises took advantage of the fact of this economic situation in which there was a surplus of offer of workforce in respect of demand. And so you could take the job or leave it. I mean, you had no choice. And as a matter of fact, it's very interesting to see how in the US immigration policies at the end, second half of the 19th century and the beginning of the 20th century are somehow driven by the need of having more workforce. There weren't enough workers to work in powerful US industry, and therefore you needed to bring in workforce. And so there were specific policies allowing immigration, because there was need of workers mostly in the industry. So just to point out that this is, if we look at it from a social and economic point of view, and we see how industrial development went well, it was mostly obviously at the expenses of the workers, who could do nothing else but work. And we have a whole lot of descriptions in novels, both English and American novels, of how the workers were used and how much they had to use. They had to work in those ages. And so only things start changing, and this is something that we have studied in history, when starting from the second half of the 19th century, we have workers start to organize themselves in trade unions. This clearly is the development of socialist movements, of Marxist ideology, but not only that, because also there's a social tendency in many Christian confessions which have this social tendency to organize workers and to demand that workers should receive what is the just pay. So, and trade unions, so we have trade unions and political parties. Typically in Great Britain, the Labour Party; in the European continent, mostly socialist parties, that eventually then find, in one way or another, they find their way in Parliament and start making their social instances a parliamentary and a legislative issue. So what was until then just simply left to the pamphlets of social reformers and of sporadic sort of protesters, now it becomes a political movement and a work organization, mostly, as I've mentioned, through the role of trade unions. If we don't see what the role of trade unions, I mean, obviously one can sort of challenge and say certain aspects we do not agree, or one does not agree with this, but they changed the whole system from a very small political system in which it was governed by those who had and who had an income, had an estate, were while the vast majority, and they had education, and they were employers, and the vast majority of the population had nothing. They didn't have instruction, education. They didn't have. They had difficulty in finding a job, and so all this changed completely the shape of Western society. So we have to consider this social revolution, which happened starting from the second half of the 19th century and went well into the 20th century. Now, this has profound influences on the law. The law obviously reflects social and economic changes. We have seen them in certain aspects. We have to see it also in these aspects. So let's see if I can move down to my next slide. So what do we have at the end? And we find this common throughout Europe, all European countries more or less, with a little bit, some before, some later, start having these first social reforms in the field of working conditions towards the end of the 19th century. If we look at Italy, France, Germany, Great Britain, more or less in the same times, we have the same kind of first very important social reforms, and these social reforms are obviously put into place by the law. It is Parliament that introduces this law. So this is the first point. Before it was simply private law. Now it becomes more and more public law, and it has to do because it concerns a great majority, a vast majority of the population, and it is left not only to private contracts between individuals who use private autonomy to regulate working conditions, but they are set by the law. And so we find first, most important, right to strike. Now, this is very important because right to strike was considered, not only you were not paid, but it was considered some kind of subversive activity and challenged. And we have a whole lot of history tells us that there were very strong repressions of strikes by workers wherever throughout Europe, and this had very negative and also in the US. And obviously, this was a demonstration of the fact that that striking was not allowed. Striking was seen as an insult to public order and to what the establishment thought that workers should just work and that's it, and should not complain about working conditions. So this again has very much to do with the social evolution of Western societies, but at the same time, it is no longer strike, is no longer only a fact, something that happens. It is a legal right. Workers have the right to strike. Now, this is important because we see countries where, well, this right to strike does not exist. So we are interested in seeing how, this is why we're concentrating on Western legal systems, and seeing that in other countries, well, this right to strike does not exist, while we have introduced this, well, more or less around the end of the 19th century. Collective bargaining, and this is something that we shall examine further on, and it's very important because it changes the whole private law perspective. Minimum pay, maximum working hours, protection of women workers, prohibition of child labor, compensation for working accidents. Now, these things today are, for us, we feel them absolutely natural in any Western system. Well, at that time, they were not natural, they were not obvious, and they were the result of a very long social conflict, which finally came out in parliamentary interventions, in legal interventions, and all those who saw that this was necessary to ensure social peace and social order, and that the state was of all its citizens and not only of those who had an estate and had an income. Well, this is a very profound change in society and politics. One could easily put together these social reforms together with the political reforms of voting. When do voting rights are extended to all men of age, and then subsequently also to women. So just to show you the relationship there is between social labor reforms and voting rights in to have representation in parliament, and therefore to be able to influence the legislation. So once this starts, and this starts, as I've mentioned, from the end of the 19th century, what happens is that labor law did not exist. It was simply just a contract like any other, or rather you rented out work, and well, there were some particular cases, but generally private law was considered sufficient. Now, what happens once we have this flood of legislation, social legislation, legislation in the field of labor performance of work? Well, we have this emergence as a branch, a specific branch of the law, labor law and law of industrial relations. There are two, they both are together, but while labor law is more related to the relationship between the employer and the employee, when we look at the law of industrial relations, it is more related to the role of trade union or of workers' organizations in somehow defining a whole series of aspects of what the workers should do, should not do, and working conditions. So these are somehow related. So this becomes a specialized branch of the law, and which is quite distant from private law origins. When you will study, I'm talking to our Italian students, you will be studying private labor law, you will see that the origins are in private law. We talk about contract of employment, but then we see we move very far away, and we can not really apply ordinary contract rules to a contract of employment. We can apply it to other kinds of contracts where there's some kind of professional activity made, but generally when it comes to the relationship between employer and employee, we are pretty far away from traditional private law principles, whether we are on the European continent or we are in the UK or in the US. So just to point out that this has profound changes in our legal systems. Well, there have been profound changes in in all our legal systems over these last 200 years, over the last century. But the emergence of labor law and law of industrial relations is one of these significant changes. Why? Because it is not, although it has lost many of its private law background, it gains a whole lot of relations with other parts of the law. Typically, company law, which is, we shall see in a moment, and obviously welfare law. Company law, why? Because following sort of the socialist ideology and I would say more Marxist ideology, and which is somehow tempered by, obviously, by social democracy and by social. Sorry, someone has their mic on. Sorry. We see that in certain countries, and the best case is that of Germany, which is, as you know, the biggest country in Europe, biggest from the number of inhabitants, over 80 million, and it has a very long history of a country where Industrial Revolution was particularly developed, and so on, has a very powerful industry. We see that in German companies, big companies, listed companies, workers, the so-called co-management. That is, that on the board of these companies, take for example Volkswagen, just to make a case, we see that practically half of the board is made up of representatives of the workers, of the trade unions. So what does this mean? That the workers, so in those who direct, who manage a company, are not only the shareholders, the owners, those who have put the money in the company, but also those who are working in the company. Now this is a model that has been tried to be replicated in other countries with not the same success as it has had in Germany, but it is just to point out that this has, if we look at German company law and we look at big companies, well, this is particularly important because when we're looking at the management, we are interested in knowing that shareholders of a German company can elect only half of the managing board. When there's a shareholder assembly meeting, well, the shareholders, those who have put the money in the company, who own the shares, will be able to designate only half of the board, and the other half of the board is instead left to the trade unions. This has obviously some effects which can be considered negative, but it also has, sorry, apologize for this, but it also has some positive aspects. We see that in comparison with other countries, there are much less strikes in Germany, generally speaking, if compared with other European countries. Why? Because the company generally there's no confrontation between the management of the company and the trade unions, because the trade unions are in the management. So this brings some kind of accommodation before the conflict explodes. So just to point out, there are, from a social point of view, there are some quite a lot of beneficial aspects in this co-management. The problem is that co-management has not really been able to express itself in other countries in the same way. Just let me see if there are. Sorry, I'm just looking at the chat. Don't see why. Sorry. Well, okay. So just to point out that this is one aspect which is very important. Looking how labor law has an influence on company law, and also when it comes, and we should see it later on, when you start moving, your idea is that of moving a company. Obviously, you will, when you want to go from one country to another, you will look at labor law, and obviously with welfare law. This is why in this my presentation, I have put sort of labor law within the notion of the welfare state. We could also put it in, if we're looking at private law, company law, and labor law. It's in between. It is, we could put it in the previous module or in this module, just to show you that all of these branches of the law are interrelated. The other element that I would like to draw your attention on, which is very important, is that with the after the Second World War, the constitutions that were introduced had specific provisions concerning the role of workers, of trade unions, and somehow the role that these workers and trade unions have in defining policies and their representation. Now, this is very important because here we find a group that is workers which have a specific role in a constitution. So we have right to strike, trade unions, and other forms like in the German constitution. Typically, as I've always mentioned, two main constitutions are the Italian Constitution 1948, German Constitution 1949, and in the German Constitution of 1949 is an even stronger social push towards representation of workers in institutions. So just to point out that this has influence also on our constitutional systems and our fundamental rights. When we look at, if you go back to the first lessons when we were discussing the European Charter of Fundamental Rights, we see that there's a whole section which is devoted to workers' rights. Very specific rights, not generic rights, but very specific, which concern the working relation, the relationship between the employer and the employee. So this is labor law has become since the modern post-World War II constitutions has become a constitutional issue, which is obviously, this means again that we must take into account these aspects, and we cannot just place the problems of working relations, of labor relations, just as if it was one ordinary branch of the law. No, it has significant and profound constitutional implications. Obviously, there are different points of view, and that is quite normal and quite justified. Different points of views. Obviously, trade unions have a certain point of view, employers have a different point of view, and the problem of parliament and government is finding the sort of point of balance between these two different points of view. Now, let's go on, because the first, once we move from this general outlook, what happened, how things were in the past, how they are now, what we are interested in first point is that when we're talking of workers, we are generally talking of employees. Someone who is employed by an employer and receives somehow instructions on how the person the worker should work under the direction of the employer. And we see that over the last, well, 140, maybe 150 years, well, the main scope of labor law legislation is in the field of employees. That is, people who work under the direction of an employer and not of self-employed. Now, the problem is, and this is the first distinction we have to do, and we have to do it in Europe, but we have to do it also in the US, whether someone is employed, is an employee, or is self-employed. What is the main distinction? The main distinction is that in the Western system, if you are an employee, you have certain amount of protection, varying, and we shall see what this protection is, while if you are self-employed, you have very little protection. Typically, self-employed people are traditionally so-called liberal professions. Think of lawyers, doctors, architects, and well, professionals. And those are considered self-employed. They take a risk, they are free, they can choose whether they want to work, how much they want to work, and they can establish more or less what they can ask for, and so on. And so self-employed means generally that you do not have that kind of protection which is generally afforded to employees. The problem is that as this protection, as we shall see in a moment, is costly and costly for the employers tend to try to somehow not to have employees, but to say, well, you are self-employed. I'll take a typical case which happens all around the world. When someone has a person that has to do house cleaning and it comes twice a week for a couple of hours to clean the house, and the sort of the employer, the house owner, says, well, this is, you are self-employed, you're just a professional cleaner, and I will pay you as if you were a professional cleaner. And therefore you're self-employed, and I will not give you those guarantees which are typically of an employee. Now, in all Western systems, when the case is brought in front of anybody who has to decide, and we should see this, well, they say, well, no, sorry very much, this is not a self-employed person. It's not a cleaning professional. This is someone who is cleaning under your directions. You tell the person when the person must come, must clean, what should do, what shouldn't do, and therefore it is, you are the employee, and therefore you have the typical responsibility of an employer towards the employee. If that employee slips on the floor and breaks its leg, his or her leg, well, this is your liability, and as if it were an employee. So just to point out that, but this is a very tricky distinction, because there are some areas where you're not clear if they're employee, if you have an employee or self-employed. Typical case that we found around the world. Are Uber drivers self-employed? They have their car. There's a platform tells them, you go here, you go there. Mr. Uber doesn't decide where they must work, how they must work. They just tells them, gives them a digital platform. They receive calls and they go from one place to another. Only thing that is set are the fares. That's all. Are they employed or self-employed? Or what they call also the riders, all these young people who are on bicycles, and sometimes they're more lucky they can allow to use scooters, and they bring food, Deliveroo, Foodora, Eats, and so on. All these riders that bring food, and now also they bring also shopping from the supermarket. Are they employees, or are they of the Foodora or whatever company it is, or are they self-employed? Now, this is, as you see, it's a very delicate issue. Recently, we've had decisions around in the Western world, not only in Italy but also other countries, saying no, they are employees and they must have certain kind of protection. They are employees, and who is the employer? The platform. So the digital platform has certain responsibilities. If the rider has an accident while he or she is carrying out the delivery service, well, the company that has provided the platform is liable and must pay sick pay and whatever compensation, injury compensation, and so on. So just to point out, as you see, transformation of society makes this distinction between employees, that is subordinated workers who work at the direction of an enterprise, and self-employed. Well, typically complex issue, but it is very important when we want to compare systems and labor law systems to understand what is the boundary, how do you establish whether someone is employed or is self-employed. So just to point out, and this is obviously a legal issue, and that is sometimes set out by legislation, sometimes set out by case law. Then, second element, once we have seen that that certain workers, not all workers, because obviously a professional is a worker, a lawyer is a worker, a doctor, who doesn't work in a hospital but works a general practitioner is a professional, is a worker. But once we have somehow set the indication of where is the boundary, how do we establish if certain workers are employees or they are self-employed, then there's this issue of collective bargaining. Now, collective bargaining is, if you think of it, now it's common. Collective bargaining is seen as a fundamental principle especially often set out in constitutions, and surely it is set out in the Charter of the International Labour Organization, which is the labor branch of the United Nations. So we take it for granted, at least in Western societies, that there is collective bargaining. However, if you think of it from a typically private law perspective, well, you start saying, well, what happens? Here we have someone, a trade union, or an association of enterprises. These two entities meet, join, discuss what the conditions of the contract of employment should be, and then, and this is where the distinction is this agreement, this collective bargain that has been reached by the trade union on one side and by the association of the employers, is it binding for everybody? How can it be binding? Now, this is, as you think of it, from a private law perspective, you say, here there's an agreement, and well, this is what we would say if we looked at this only. Sorry, just let me write this down. I'm trying to see where don't I find my, sorry. Just let me write this. Sorry. So, I mean, Latin, we obviously we use Latin, but as I've mentioned several times, English lawyers and even more American lawyers love Latin. And so there's nothing wrong in using these nice Latin expressions which are compact and say everything. Res inter alios acta. So from a private law perspective, we say, hey, listen, I'm a worker. Why do these conditions which have been established by a trade union, I'm not a member of the trade union. How can they bind me? Another company and an employer says, well, I'm not part of this employers association. I'm outside. Why should I be bound by these agreements that are have been reached by the two trade unions and association of enterprises? So just to point out that from a private law perspective, it somehow we could question this, and when you will study, those of you who will study industrial relations, you will see that sometimes, well, these collective agreements are not always completely binding. But anyhow, let's move on to. Sorry, just let me go back to the slides. Point of collective bargaining, this is a significant change. It has you can see it, if you look at it from an economic point of view, it has it is enormously efficient, because if you think that each worker should bargain, start bargaining with the employer, or each enterprise should bargain with all the workers, well, it really makes it much too difficult. It makes it practically impossible. So surely there's economic efficiency and interest in all. Sorry, just one second. There's sorry, I'm my office, so unfortunately nobody's answering the phone. So the point is that so there's economic efficiency in collective bargaining, but obviously this has brings certain limitations of private autonomy, both of the employees and of the employers. So just to point out that, as usual, we have good sort of positive aspects and less positive aspects. But then not only do we have the issue of collective bargaining, but often we have in all Western countries, we have the legislation that intervenes and establishes some basic principles of the contract and establishes certain elements of the contract. So, as quite often happens, you find a contract that is partially already written by Parliament and that can be modified by the parties, but modified only going up, not going down. So generally what Parliament does in all Western societies is sets a floor to what the working conditions must be, and then clearly you can lift this floor, you can go up. You cannot go underneath this floor. For example, what are the minimum guarantees set by law? Legislation. Does legislation set a minimum pay? For example, nobody can be paid for, obviously, for the ordinary job less than, let's imagine we are in continental Europe, less than, let's say, 700 euros per month. Just to say, does the law set this, or is it left to collective bargaining? Maximum working hours. Now, this is very important. I mean, there have been some experiments, for example, in France, establishing that well, working hours should not be more than 35 per week. Now, this was disastrous, had disastrous effects because clearly made everything, made disincentivized any kind of working activity in France, investments in France, because you know that French workers could not work more than 35 hours a week. So, I mean, you on the one side, you want to protect workers from what is considered exploitation by capitalistic enterprises, but then at the end of the day, what you're doing, you're reducing the amount of people who actually will be working. People will be working less and less, and then finally will be unemployed. So that is, maybe that's perfect. So instead of working 35 hours, they work 0 hours, and so. But this is surely not the best interest of those who want to work and want to have a salary at the end of each month. So just to point out that this is, but the legislation can establish or could establish maximum working hours, especially when it comes to certain kinds of jobs which are particularly sort of difficult. Just take, for example, the case of truck drivers, those who are on lorries that transport goods from one part of the other of Europe, and you set a maximum number of hours. Why? For their safety and for everybody else's safety, because if the driver is tired, well, clearly, obviously, the case that there's an accident, a disastrous accident, well, that is very high. So you reduce the number, by law, you reduce the number of hours that these, or you set the maximum number of hours that these truck drivers can drive. So you see that there's it's not only protection of the individual worker, but also protection of the everybody else. Then rest during work. Now this seems again sort of somehow might not be significant in certain jobs. Just think of someone who's working in an office and just decides wants to go down to the bar and have have a coffee or just have a snack, or there's a brief lunch break. But in other jobs, surely you have to understand if it is a very difficult job, if the workers have by law the right to have to rest. And again, paid holidays. What are the holidays? For example, generally in Europe we find 4 weeks. In the US we find 2 weeks. Now this is very significant. The difference is it makes an enormous difference whether you have 1 month more or less of holiday, of paid holidays, and when you only have 2 weeks of paid holidays. So this is just to show you that there are significant differences in models, and we compare models not on the basis of very theoretical principles, but saying how much holidays do you have? One worker, two workers who are working in the same sector, who are in the same, let's imagine the same enterprise, which has a US branch and a European branch, and the US branch, the worker has, let's say, IBM. Let's imagine IBM, which has branches around the world, and an employee of IBM in the US has 2 weeks of holiday, and the worker, his co-worker, who has the same position doing the same job in Europe, is told, well, you have 4 weeks of holiday. Well, makes a certain difference in, and especially if it is established by law. Then the problem of workers is not only sort of when they are employed, but also who is employed, when, how do you find a job. Now this is very important. In a welfare state, the idea in a welfare state is that there should be zero unemployment, that everybody should be employed, more or less, but everybody should be employed. We see that this is pretty difficult, and the European solution is traditionally has been that of having employment offices. What are employment offices? They're public offices where people who are unemployed go and say, listen, I'm looking for a job, and this employment office is an intermediary between the person who's looking for a job and the enterprise. Obviously, trying to match what profiles, what the enterprise is asking for, and what the worker is able to do. Now, to what extent must enterprises necessarily go to the employment office when they are looking for some kinds of workers? Must they pass necessarily through the employment office, or can they just go on the free market? Can they go to private employment office? So the point is, to what extent does the employer have the possibility to choose the employee? Now this is very important because certain employers want to choose for the kind of job they're doing. They don't want a generic worker. They're looking for a kind of specific employee which has a certain curriculum, has a background, and so on. So just has references and so on. So just to point out that this also is very important, the role through which the state somehow finds a job. So it's not the individual that goes and finds himself or for herself a job, but it is the state that somehow places workers who are people who are looking for a job, places them in some kind of industry or enterprise. And then obviously we have other social aspects. Think of the cases of people who have a physical handicap. Think of people who typically who don't see, blind people who are would never find an employment if they were not the state did not establish that in the medium and large size enterprises they must be a quota of workers that are physically handicapped, whether they could be maybe they're impaired in their sight, in their hearing, but they could be also impaired also in their movement. So this is, again, this is very important social aspect, which, and if you look at the European Charter of Fundamental Rights, we see that when we talk about rights of handicapped people, we're talking social inclusion, and social inclusion is not simply that they can go out on the streets when we will be able to go out on the streets and go to parks and so on, but also to find work. And so this shows you that, I mean, what is the role of the state in finding a job for its citizens. So just to point out that this is another aspect in which we somehow distinguish, and we sort of we try to understand to what extent the system is more or less pro-social, more social or less social. Social, by social meaning, which trying to encourage a vast inclusion of workers and granting workers their the maximum rights possible. Then the further element, and this is very important, and it is one of the main distinctions between the continental European system and the US system, is the length of employment. Now, traditionally, in continental Europe, starting mostly from the end of the 19th century, employment was unlimited in time. So the whole idea, and the idea that we have made in continental Europe, is that once you found an employment, well, that employment is for life until you retire from your for old age, and therefore that's the that is the system. Please keep in mind, it's not something that is only European. If you look at Japan, Japan is a place where not only employment is for life, but once you enter a certain company, you will remain there. You are faithful to the company, and the company is faithful to you, and therefore you will spend all your life in that company, and the company will take care of you even after when you finished your working. So just to point out that this kind of unlimited time model of employment is quite common, and it is the general model on which we have been shaping employment law over the last 70 years. What is the problem? When you start changing this the structure of society, you don't any longer have the typical kind of companies that you had, factories, places where workers are all together, where you need lots of workers, of employees, and therefore the whole idea is that of a lifelong employment. Now we find significantly vast areas where people tend to change their job and not to have a lifelong employment. Let's take the case of a Foodora or Deliveroo or Eats rider. It's generally a young person who has spare time and then hopefully is going to find some different occupation. That person is not going to, even when they're 65, they're going on their bicycle, maybe with electrical aid to deliver food and climb in. Maybe there's a building with no elevator and they have to do 3, 4, 5 flights and bring the food up to the doorstep. Just to point out that so gradually we are seeing that the working models are significantly changing, and therefore it is the model of unlimited working, lifelong working employment is no longer even in Europe the model, while in the US, generally, not always, generally it is a limited in time. We find it in many jobs, especially when it comes to when you're working for government. Government in the US means not only the federal government, but the state government of the 50 states, or in certain industries, it is unlimited time job. Typically in the auto industry, you find a job in the automobile industry. It is most commonly trade unions have managed, strong trade unions have managed to have an agreement by which it is a lifelong job. But this issue of limited or unlimited time in the contract of employment is again one of those significant differences through which we compare systems. Sometimes it is also due to social attitudes. Typically in the US, people tend to, there's much more flexibility and mobility. Mobility from one job to another, and mobility also from one part of the US to another. This is very typical in the US. You start working in Massachusetts, then you move to Arizona, then you move to Washington State, and then you end your, if you've made enough money, you end your life up in Florida. And this is quite typical in the US. We don't find this kind of working mobility and family mobility, we don't find it in Europe. Whether we're talking of Italy or Germany, Spain or Finland, we don't find all that mobility. At the beginning of a career, you find mobility, and then there's much less geographical mobility. So this also has very much to do with the span, the time span of the working contract. So just to, when we're comparing working law, labor law, well, we shouldn't just think that every country is the same. We should also think that each country has a different structure, which would be a social structure, an economic structure, big enterprises, small enterprises, medium-sized enterprises, and also attitudes of citizens towards work. Are people happy? What are they looking for? A lifelong employment, or are they looking instead for something different that opens more opportunities? We see that in the US. It's not, again, it's not the US are strange and they have a sort of an obsolete and exploitative labor system. It is that many American citizens want to feel free, and they don't care all that much about lifelong employment, and they think they can find an employment for themselves, and they can want to be able to change their employment with a certain ease. So just to point out that this is when there's lots of sociological research behind this, and this explains also why in certain countries we have certain labor law legislation, and in other countries it's different. Then a further issue in which we must compare, and this is a very sensitive issue, the problem of termination of contract. What is the termination? So whether we have, especially when it is an unlimited time contract. So we have a contract of which is of indefinite length until the person is retires, and so it could be 20, 30 years, 40 years, it could be lifetime. But also when you have a limited in time, let's imagine quite a long time for a contract of work, let's say 3-5 years. So termination of contract. What are the legal basis for termination of contract? Now, obviously, we're talking of lawyers. We are interested in understanding what are termination of when an employer can terminate the contract, and when can the employee resist this termination of contract. So this is very important, and lawyers are deeply involved in this kind of litigation. So first of all, disciplinary reasons. What are the reasons? Which are disciplinary reasons that that allow an employer to get rid of the employee? Or again, another issue: what are the when an employee has an unsatisfactory performance? So what happens when the employee has an unsatisfactory performance? Can you get rid of it? Let's imagine an employee who's always arrives late for job, or is very doesn't really take notice and does many mistakes in his or her job. Can you dismiss this worker? Can you get rid of this worker? Well, this is also it is set out in often in collective bargaining, but it is set out also by case law. Just 1 second. So this is, and then there's also this very significant issue, just which is unfortunately a very actual issue, that of collective dismissal. Let's imagine that for an industry has to close because it cannot work, and it knows that it won't be able to work for the next 2, 3, 4 months. Well, can you do collective dismissal? Can you dismiss your workforce you have, or you expect that nobody will be buying your products any longer, and therefore you reduce significantly your workforce, and therefore you dismiss, let's say, half of your workforce, 3/4 of your workforce. So this is collective dismissal. Is very complex issue because, well, this could also be what are the kind of who chooses who should be dismissed. And we see the trade unions are often afraid that dismissal will be done done on a discriminatory basis. Therefore, that certain workers who are not liked by the management will be dismissed, and others, those who are more management friendly, will be kept to work. So just to point out, this is economic reasons. In times of economic crisis, this is a very significant aspect. Then we have this American model, which is not the model for all the US. We should keep this in mind. It is in certain sectors where there's no collective bargaining, typically financial enterprises, Wall Street, for example. There's this hire and fire model. What is hire and fire model? That you need workers on one day, and you just hire the worker, and then you don't need the worker any longer, and you just fire the worker without any consequences. Now, this hire and fire model has obviously certain, well, from the employee's point of view, it's not very pleasant to be, because this is what happens in the US. In certain sectors, you arrive to work at 9 o'clock, and you're called to the human resources office, and you're told that you're sacked and you're fired, and that that you must pack up whatever you have there, and in 1 hour, 2 hours, you must be out of the premises of the industry, which is clearly not very nice, because you're thinking you have a job, and you lose your job over 2 hours. You've already lost your job. Now, this is unpleasant from the workers' point of view, but see from the industry point of view. The industry, this means that when the industry has a strong request, just imagine that, well, now we need a whole lot of products which are related to the coronavirus pandemic. Just think of masks or ventilators, and well, you just hire 100 people, 200 people that are doing this job, and you just from day to tomorrow, without any limitation, just hire, and then when the crisis is finished, you just fire them. And so this gives the enterprise, from the enterprise's point of view, gives it a very strong flexibility. It can somehow organize its workforce in accordance to the production. This has also, one could say, oh, but this is only the interest of the employer. Only the employer takes advantage of this. Well, there's also an interest of consumers, of those who buy the products, because this means that if you increase significantly the production of certain products, this means that the cost goes down. So you should also see that from a consumer point of view, well, if there's too much rigidity in the production, these products will cost a lot, But if the enterprise can produce as much as it wants because it has the worker, it has workforce, well, then clearly this means that cost will tend to go down. So just to point out, this is as usual. We always find various points of view, and the point of view of the employers is not always the point of view of the employee, but the point of view of these two parties is not always the point of view of the consumers, which may have different interest, and then other interest of, take for example, needs of environmentalists who think that the overproduction is bad for the environment. So just to point out that we should always take into consideration when we're looking at these aspects the many interests that are somehow involved. And again, what happens once someone has been dismissed? Does this person receive unemployment benefits, or are they layoffs? What is happening around Europe? The fact that you don't go to work. Many people don't go to work, but part of their salary is paid by the state. So we find the social security net by which, if you lose your job or you are unable to go to job because your activity has been closed, because the government has closed that activity for health reasons, well, you receive part of your salary by the state. So this again has very much to do with sort of termination of contract, and especially when we find collective dismissal, what happens in these cases. And we want to compare these aspects and see what are the consequences in this when these things happen. Then again, just to show you the amount of issues, and I will stop here for today. We've seen labor relations. I would like you to focus on what we call industrial relations. Call them industrial relations because obviously it was the times when there was industry. Industry was the main economic activity, secondary economic activity. Now we've moved well over industry. We've gone into services, financial services, digital services. But anyhow, let's talk of industrial relations. In industrial relations, well, there is an important role of trade unions. I've mentioned how historically labor law is the result of organized labor, which has put economic, social, and political pressure on government and parliament to obtain certain protection for workers. And now we find that this is quite obvious that this protection should be there. However, I would like to point out that this strength of the trade unions is significantly generated by the model of industry of the 19th century and most of the 20th century. That is the idea that there's a factory or there's a workplace where people go, join work together. Just think of a production chain where all the workers are somehow connected one with another. Each does part of the job, and then they all meet in the canteen when there's a lunch break, and they somehow discuss various issues. So in this model, which is a typical 19th century, early 20th century model of a factory, clearly trade unions are organizing workers who are in the same place. In different contexts, in our contemporary context, where workers are more and more delocated, just think of the case of now what happens. I mean, it's so-called, we call it smart working, but I don't know if it's smart, but surely it is working. But workers are put in different parts and they can't join, they can't discuss, well, the role of trade unions is much less strong. And this all around the world, we see that trade unions are losing strength. And therefore, when trade unions lose their strengths, clearly this creates issues when it comes to collective bargaining, because there's no, just think of the issue of riders. It clearly creating, here we have thousands of people in a country, let's imagine in Italy, but it could be in Belgium, France, Germany, or UK, who are completely separated. The only thing that keeps them together is a digital platform, but their employer is someone somewhere in the US and just created a software, and that's it. And what chances do they have to get together? Practically none. And so the problem of organizing a trade union, just to point out, this is not the organization of trade unions, does not have to do with the law in itself, because trade unions are can be freely organized, but their functioning, their role obviously diminishes when we have a different organization of work, which is significantly different from that of the late 19th century and of the 20th century. And then just think of the role, which is increasing, the fact that in factories, well, we have a whole lot of machines, automatic machines, robots. And so this has obviously, until sort of we have intelligent robots who start saying, oh, but I'm working too much and I want a trade union of robots, this is something that is somehow widely, if you look at Isaac Asimov's novels and short stories, you find all the issues on sort of robots and some robot workers. But apart from this science fiction, which is not really science fiction, but clearly we see that factories are becoming less and less dependent on physical workers and more automated. So what is changing, and we are interested as lawyers, and you especially should be interested as young lawyers, budding lawyers, when trade unions have sort of diminished, clearly this role, political role, which is very influential in many countries in lawmaking process, when there are laws that somehow have to do with working conditions, trade union is always there saying what should be done and what their position is. And then when it comes to the budget is significantly a social budget, just think of benefits for workers, pension, taxes, how much should employees pay in taxes? Well, trade unions are there. So just keep in mind that obviously there's a political sphere which is interesting, and it's not our job as lawyers to sort of discuss the political role of trade unions or even political parties, but we are very interested to see what is the outcome when we have, what happens when there are very strong trade unions, when there are weak trade unions, when there are no trade unions in certain sectors, there are no trade unions, and therefore that kind of legislation that is introduced in activity, working activity in that sector clearly is much less strong. Then, right to strike. As I've mentioned, in the 19th century, when industrialization starts, when workers start striking, and we see them starting striking in mines, coal mines, collieries in Great Britain, very fierce strikes in the 19th century against working conditions, which were really appalling, and there were no safety for workers, and workers were getting killed dozens every day. And so from that, when striking was considered subversive, it was some kind of attack on the order of an orderly society, and the fact that, you know, industry could not work if workers could not operate if workers started striking, then we see that gradually, end of the 19th century, we find this idea that the strike is a fundamental right, and therefore every worker should have, from an organized point of view, should be able to organize a strike. But however, we see that strike in all countries, we take Germany, France, Great Britain, or Italy, I'm taking biggest European countries. Obviously, we could see this also in Netherlands, Austria, or Belgium, we could see smaller countries. Problem with the right to strike, there's a general provision, especially often in the Constitution, which establishes the right to strike, but then with certain limitations. We find certain limitations. For example, who can call a strike? Can I strike? Listen, I don't like the rector of my university, and I think this idea that I have to do video lessons, I find it really diminishing of my professionality, and so I want to strike. And I decide I strike. Can I strike? Well, no, I cannot strike. It is who can call a strike. We see that only trade unions can, or organized workers. A workers' organization can call for a strike. So first of all, strike is not simply just saying I'm challenged the management, the company, and I don't want to work. You don't pay me, but I'm going to picket in front. I'm going to go in front of the company headquarters and complaining about the company. No, strike means organization of a strike, which can be called only by certain entities. So this, first of all, is the first limitation. Then secondly, strike, when, how, who, it's not the same. Let's take some case in essential services. Just let's imagine that the doctors and paramedics who are under stress, incredible stress, all around Europe in this, and they have received they're working in very dangerous conditions, and surely they have not received any pay increase by the state has not paid them any more money for the enormous work they're doing. They say, hey, listen, sorry very much. Well, we've done an enormous amount of work, but we're striking. We're going on strike. Can health workers employed by hospitals go on strike today? No in all European countries. And so we start establishing which workers can and what extent they can strike, for what reasons they can strike. Transport workers, we find disruptions of transport in many European countries. We find devastating strikes especially in France, but also in the UK, much less in Italy. Why? Because regulation is different in Italy in public transport than it is in France or in the UK. So just to point out that when you talk about right to strike, well, it's not a universal right which is regulated in the same way all around the Western systems. There are significant differences, and these differences are very important when we compare. Typically, just to make a think of rail workers, train workers, those who work on train. Can they call in France? Over the last and also in England, they were calling strikes for 1 week. 1 week, the trains were all blocked. This has very significant effects on the economy and on the rest of society. Maybe the rail company is not happy, or maybe it is happy, but what are the consequences for citizens? So this right of workers, of employees to strike has to be somehow coordinated with the right of societies who have the expectation to receive certain social services. And then again, just to point out, role of government in solving labor conflicts when this trade union versus employers association does the government step in? Does it have a role of mediation? Can it mediate or not? And when it comes to some kind of solution, how is the solution going to be binding for the parties? Then who solves instead individual conflicts, not mass conflicts between trade unions and associations of employers, but between by the single employer and the single employee. Who decides these conflicts? Is it an ordinary court? Is it a specialized court? We find round or specialized mediation, dispute resolution centers. So this is also very important because we see that how labor law is significantly can, under certain aspects, a judge-made law. So it depends very much on who decides this conflict. So again, this shows us the relationship between the models of conflict solution and how the law is. And then finally, just to close today's lesson, we find that I just recall David Ricardo. David Ricardo is with together with Smith, is the founders of modern economics, and in the beginning of the 18th century, David Ricardo came out with this principle of the theory of comparative advantage. So when you produce, and this is very relevant in international trade, you go to a country where, not the country where it costs less, but where comparatively you have a better advantage, you have a comparative advantage in producing in that country. Now, 2 centuries after David Ricardo, well, industries still follow this idea of comparative advantage when they delocalize their production. Why? Because they find that in other countries there is more benevolent labor legislation, and especially social security costs are lower. So this is just to point out that this brings us also to give us an idea that in a globalized world, when we compare working models, obviously we are interested in understanding how the labor legislation and the social security law and industrial relations law are regulated in different systems, because this encourages investment or discourages investment in a certain country. Now, this is what I wanted to try to present to you today. And now just now let's see. I have a question, Nikolai. Sorry, go ahead. Sorry, I went ahead and Nikolai, what is the question? You want to type the question, or do you want to? I don't mind if you speak, Nikolai. I mean, I've noticed that sort of some of you are rather silent. So please, if you have, if you want to open the mic, Nikolai. What is the question? Anybody else has questions? Oh, who's there? Who's speaking?
Nikolai.
Yes, go ahead, Nikolai. What is the question? Hi. Your mic is open.
Sorry, I had a problem with connection. I wanted to ask if you could can you repeat, please, the fact about co-management in large German companies? I didn't understand.
Co-management. Now, this is very interesting, because this is a model, I repeat, this is a model that is set by law in Germany, and that other European countries have tried to apply, but with not the same success. What does German company law establish? It establishes that in certain companies, not all companies, but first of all, companies that are of a certain size and that are listed publicly, that listed on the share on the stock market, a certain amount of members of the board, as a company has a board, and has managing members of the board. Could be 10, it could be 7, it could be 15, depends on what the bylaws of the company say. So what happens in Germany is that a certain amount, which is generally tends to go towards half of the board, represents the workers in that specific company. Now, what does this mean? This is you could see this as a socialist invention. It is surely it is social democrat, but it has had, at least in the German system, it has had a very strong function of lowering conflicts. Because while what happens in an ordinary company, there's a board, the board represents the ownership of the company. This ownership can be the owner, the founder of the company, the Agnelli family, or it could represent the shareholders. And they are thinking only of the best interest of the company, and the best interest of the company is that of making profits. So this is mostly the shareholder's point of view, and the shareholders are represented in the management of the company. When you have trade unions in the managing board, this means that the trade unions say, hey, listen, you shouldn't only consider profits for shareholders, but you should also consider what are the advantages and disadvantages for workers. So typically, if the company has, or companies do this, they say we have too many workers, we must cut down. There's a redundancy, there's too many workers, and we must fire 1,000, 2,000, 3,000 workers. Well, this obviously creates significant conflict. In other countries, this would bring immediately a strike. In Germany, the fact that this decision has to be made by the board of managers, and in the board of managers there are trade unions, this somehow justifies a very conservative approach of the management that says, well, this is what we actually do need, and we are very displeased in having to cut down our workforce, but we must reduce it, and we will reduce it with the agreement of trade unions. So, but this is very important because it has a deep influence also on German company law, which is different from company law that we find in other European countries. So so who is represented when we look at the shareholder meeting, and who votes at the shareholder meeting, and who is represented on the board of the company? Well, this is very important because it means management of not only one company, but of many companies. We're talking of big companies in Germany. Germany has, just think of Volkswagen, Siemens, and Mercedes, and all the automotive industry. The pharmaceutical industry has very big companies. Well, this means that the management is different from the kind of management that you find in other European countries. And this is a distinctive difference that you should keep in mind. But the point is that it works in Germany, elsewhere doesn't work as well. Now, any more questions? No more questions? Nobody sort of interested in your future job? Everybody is going for self-employment.
Good evening. Can you hear me?
Yes, who is speaking?
Ricardo Zinai.
Okay, Zinai. Yes, you have a subscription. You have, if there's no debate, it's Zinai and Joagnello, and I think you have a fixed speaking tribune, sort of, to tell us everything, Zinai.
Could you please explain Ricardo's model again? No, Ricardo's.
Yes. What do we have? We have these two great economists, the founders of modern economy, Smith, professor in Glasgow University, and David Ricardo, which is his follower. He's not a disciple, but he's a follower. Smith is sort of second half of the 18th century, so way back, and Ricardo is just the beginning of the 18th century. So Smith comes out with this idea of absolute advantage. So where do you produce goods? You go and produce them where they cost less. And therefore, you go, let's imagine that there's a country, a distant country, where it costs less to produce them, and you go there and produce them because you find there raw materials low, you pay less for labor, and you pay, let's imagine, very little taxes. So that is. And the only thing you have to add is transport. This idea of absolute advantage, therefore you go and produce in the country where it costs in absolute, in the whole world. Obviously, Smith was talking about in the sort of 18th century, so not all the world was much smaller. David Ricardo brings a significant improvement to this theory, and so significant we still apply it, at least in sort of in business activity, in this idea of comparative advantage. What you must do is find the place where your product comparatively has lower cost of production than your competitors. So you're not doing the lowest price in the world. You're seeing who is your competitor. Let's imagine that BMW is competing with Mercedes. Just let's make this example. So your competitor is there. You're competing on the same high-level cars, which are not luxury, not Ferrari, but pretty high cost cars. So you must have a comparative advantage, not towards everybody else. You're not interested in doing comparative advantage towards Renault or Volkswagen or Toyota. You're interested, you want to have a comparative advantage over Mercedes because you see Mercedes as your competitor. So you will go and you do your production where, compared with the production of, as you know exactly what Mercedes needs, which is what you need, you will go and find places where that part of the production costs less. For example, you say, listen, we have been all buying, let's take a very typical example. Most cars which are of a certain importance in Europe have brakes that are built in Italy. Brembo is very strong multi-industry, Italian industry based near Bergamo, and it produces brakes. It has those red brakes you see very easily that they have Brembo brakes. Now, these Brembo brakes are very good. They're sold, they're put on all cars of a certain, which have a certain horsepower that need very good braking systems, and they cost more. Now let's imagine that BMW discovers that there is a South Korean company that is producing very good brakes at a much lower price. So what does BMW do? BMW says, listen, instead of buying Brembo brakes, which are very good, I have no doubt about that, but they cost a lot. I have found that this South Korean company produces them less than Brembo. This means that when I do my cars and compete in price and in performance with Mercedes, well, I have a comparative advantage. So just to point out that this is not the absolute advantage of Adam Smith, but it is a comparative advantage of David Ricardo. And this is one of the reasons of delocalization. Why do enterprises move to a different country? Because they have a comparative advantage over their competitors. They're interested in who are their competitors. They don't want to do the lowest price. That's not their interest. They want to try to have a price that is competitive as compared with the main competitor. So this is the idea of David Ricardo. Now, Mariconda, about the role of government in the solution of major labor conflicts. Now, this is obviously politics, obviously any government should tend to solve social conflicts, whether these social conflicts, whatever the kind of conflict. Typically, historically, government has tried to mediate between conflicts between industry and trade unions. Why? Because it has an interest, first of all, because he knows that these conflicts are negative for the society and negative also for the revenue, because if there's a strike, nobody works, there's no production, and this brings a reduction of general wealth of a country and less taxes are paid. So there is also a egoistic interest, self-interest of government of solving these conflicts and not leaving, businesses closed because they close down, or trade unions, workers who occupy the squares, demonstrating and striking. So you try to solve conflicts. So it is mostly political issue. But at the same time, what we are interested in seeing is how the solution of this conflict is not simply that he puts together the two parties and saying, listen, stop quarreling and find an agreement. But the government often intervenes by putting monies in the solution of the conflict. Take, for example, the issue of layoffs. There's a dramatic financial crisis. All banks have to dismiss thousands and thousands of employees. These thousands of employees obviously are not happy and will demonstrate and will raise a significant issue in social issue. So what does the government do? The government intervenes and says, well, listen, I will introduce some special benefits, some layoffs to ensure that these workers are somehow receive payment. So the state, when the government intervenes, it generally put in money somehow, directly, indirectly, reducing taxes, giving money or giving some other benefits to help solve the conflict. So when you find these very important conflicts, you see that generally there are three parties: workers, employers, and the government. Could be also the local government. Quite often, the local government intervenes and wants to ensure that there's social peace in that region, in that province, and therefore will intervene through its legislative powers and put in money in this aspect. Which is, money means generally not simply handing out money, but establishing new rules in a certain field. Now, Giovanniello has a question for tomorrow. Sorry, Giovanniello, that fits only Arbeit engine system. Well, you just go next time you see a sporty Mercedes or BMW, look at the brakes and you'll see a red spot on the wheel, and that is a Brembo brake. But what is the question for tomorrow?
Yes, can you hear me?
Yes, I can, loud and clear.
Okay. Tomorrow we have to make the access on Zoom for the mock test.
Yes.
Okay,
so from Zoom, and I will be posting it here and sending it by email. Both what I'm asking you to work on and all the instructions, necessary instructions. I repeat, it is a mock test. Please take it with without any stress. It's not meant to. It's mostly for me because unfortunately I haven't been able to know the class as I would have liked to, and so I have to put this test, and it's useful for me to understand what is the level of English writing and of ability to present legal arguments in English by the class. So this helps me also understand how we're going to develop further with the final exam, trying to understand what's going to happen in the next weeks.
Okay, thank you.
Any more questions? No more questions. If there are no more questions, then we'll.
Yes, I have one, teacher. Can you hear me?
Who is speaking?
Di Domenico Antonio, Valerio.
Di Domenico Antonio, yes, yes.
All right. When we talk about right to strike, you mentioned it, three countries: Netherlands, Belgium, and Austria. What is the relationship between that right and this country?
No, I just was saying, what I wanted to say is that we look at big countries, Italy, Germany, France, and Great Britain, which are the biggest countries in Europe, and we find different kind of legislation in the field of strike. I'm saying that this is not only for these four countries, but also in other countries we can find differences in the kind of what the right to strike is. I mean, just take, for example, the problems of Italy. Italy, largely, transport of goods is mostly by truck, by lorry. What happens if truck lorry drivers go on strike? Well, they don't go on strike because generally they are self-employed. They have their own truck, and therefore we have to understand, how do we regulate that kind of, when they stop, they say, oh, but we're not going to provide these services any longer. We are paid too little by the those who ask carriage of goods. So, I mean, this is one problem. So just to point out that when we look at each country and we look at the right to strike in each country, we have to look also at the kind of activity that is done in their country and also the tradition. For example, in France, you cannot regulate in any way what is a very strategic sector, which is that of rail transport. Rail transport is the sort of the heart of the trade union in France, historically, since the 19th century. So, and you see that trade unions, railway trade unions, are very, very strong in France, and when they declare a strike, that paralyzes the whole country. We see that in Italy, this does not happen. It happens, it is regulated in a certain way. So just I wanted to point out that we find different regulations of the right to strike in each country. There's a different system. It's not all each country. The fact that we belong to somehow common, forget about the European Union. It doesn't regulate, the European Union does not regulate the right to strike. But we find that in each country, we find a different regulation of the right to strike, especially in social services and on who can call for a strike. In the UK, only certain entities can call for a strike. In other countries, other entities can call for a strike. This means that the right to strike is not an individual right, but it is a right of collective entities such as trade unions. So this gives you an idea that when we look at it from a strictly legal point of view, who has this right, this vested right? It's not the individual worker. It is the trade union that has this right. So this is what I wanted to try to point out.
Okay, thank you, Professor.
Okay, then see you tomorrow at 4 o'clock, and I will at 4 o'clock I will post on the screen the questions, but I will also be sending it by email, so you find it both on the website and on the Zoom platform and on your email account. Good afternoon to everybody, and see you tomorrow.
Thank you. See you tomorrow.